How do we handle the problem facing our country today with big tech? Today, I have on an expert, Ashley Baker, who will be discussing just that and more, much more, on all sorts of topics about law. But I just want to say, my name is Nick Jamel, the creator and host of the Conversation for Our Generation. So thank you for tuning in, and I guess tuning into the Conversation for Our Generation, that is, where I'm solving the problems of today with the wisdom of the past. And if you're new to the show, I hope you're very ready for a interesting episode with Ashley Baker, who is the policy director at the Committee for Justice. She's an expert at the Regulatory Transparency Project. She's does antitrust for the Alliance on Antitrust and has worked on the confirmations for Brett Kavanaugh, Amy Coney Barrett, and for Neil Gorsuch. She's really just an incredibly smart lawyer that I came across on Twitter and reached out to about coming on to talk about antitrust, because I think that that is a huge problem right now facing our country. Is how do we keep these big tech companies in check? And she has a lot of thoughts about ways we can do that and the problems and the changing definitions of antitrust and ways we need to be careful about changing that and tweaking that as conservatives. And also, she talks a lot about how to get the right kinds of judges appointed and how to peruse through that record and make sure that they are going to be a good judge. So we discuss that as well as some of the chaos around some of the confirmations she's worked on. So lots of cool stuff, lots of great information. And if you are enjoying the Conversation for Our Generation, please go to conversationfourgeneration.com/subscribe to support my work. For just $5 a month, you get access to all the premium content, my community on Discord, as well as a copy of my book sent to you. So definitely check that out and find out more. Or you can just go to wherever you're listening to the podcast or watching this on YouTube, just subscribe. Make sure you leave a good rating and review or a comment on YouTube. And those things just help in the algorithm. That's a free way that takes 10 seconds of your time if you're already listening or watching to just help out and get more people involved in the conversation of our generation. And so that really helps. So please do that. And let's get to the interview now with Ashley. Welcome to the Conversation of Our Generation today, Ashley. Thanks for coming on.
Thank you for having me.
Awesome. And so for those who are listening to the podcast and do not know who you are, could you give them a little bit of a background on who you are and what you do?
Sure. So my name's Ashley Baker. I'm director of public policy at an organization called Committee for Justice. Committee for Justice works in Washington, D.C. We work on issues, constitutional issues facing the judiciary and other issues, including antitrust law is something I've been focusing on for the past couple of years, as well as judicial confirmations.
Awesome. Great. And so right now, one of the reasons why I wanted to talk to you today is there's a lot going on. I saw that you followed me on Twitter or reacted to something randomly, and I was like, oh, this. And I just looked in because I was curious, and I just saw what you're up to, and I had to reach out because it's interesting because you're working in antitrust, you're working in, the judges, which really right now with big tech and everything going on with antitrust involved in that, but also with crazy nominations like we've had. You just mentioned before we started with Brett, you worked on the Brett Kavanaugh nomination and all of that. I think that you're kind of at the center of very hot button issues politically and culturally too, because that's really seeped in. But I wanted to get your thoughts on antitrust, and probably before we get your thoughts on it, could you give a brief background on what that is and how you approach the subject?
So just, at a really broad level, what antitrust itself is it refers to the regulation of the concentration of economic power, particularly with regard to trust and monopolies. It's an area of law that's been pretty much well settled since around 1977. This makes it a really interesting time to work in antitrust right now, as there are a lot of proposals out there and ways to change the law. But essentially, the antitrust laws, they developed in a common law type way, essentially through the courts of the Sherman Act. What the background there really is that is that so Section 1 of the Sherman Act prohibits activities that restrain trades if those restraints are restrictive of competition or unreasonably restrictive of competition in a relevant market. But what the actual text of the Sherman Act says is a little bit different, and it's restrictive to the point of that it could not really be applied and was meant to be developed through judicial interpretations. What the actual text says, it says it, Section 1 of this, every contract combination in the form of trust or otherwise or conspiracy in the restraint of trade or commerce along these several states or with foreign nations is declared to be illegal. And under that plain text reading of the Sherman Act, essentially everything's legal. And it took the courts a couple of decades to kind of explore that issue and realize that anything can be a restraint of trade, a contract restraint of trade, shoes sold in pairs, any sort of business transaction that is inherently binding.
Yeah.
So the courts kind of grappled with that for years until about the 1970s.
Mm-hmm. So basically, like a non-disclosure agreement, anything really that, because once you make a transaction, you're restraining your ability to make other transactions is basically what you're saying, right?
Yes,
Like if you read it textually.
that could be true. An NDA could still technically violate antitrust laws. I mean, it all depends on the details, of course. But just any business contract, just a commercial contract at a very basic level. Commerce was a lot less sophisticated and a lot more localized in those days too, which is something to remember in the broad context of how antitrust law developed. But it was meant to be developed through the courts, through judicial interpretations through the years.
Okay. And so what are some examples of antitrust being used in the past that maybe people would be familiar with, or at least familiar with the companies involved in it?
Sure. So, I mean, they're the standard cases, or the classic cases that everyone refers to. The AT&T case, the Standard Oil case, Alcoa, that's aluminum company, and a few others. Those classic ones, those are all very quite different cases. So it'd be hard to get into each one of them. I'll bring up a case more recently, since we're talking a little bit more about tech, in which it ultimately did, the court did side on with the consumers, and that is Apple versus Pepper. And if you remember, that is a case that the Supreme Court heard in 2018, decision in 2019, and it was over whether or not you, as a consumer, someone who uses the App Store, can sue Apple because of because they put a 30% fee on top of the app for the developers. So the law before that essentially says that you can't have passed down damages in a way that you have to be the direct purchaser. The court's opinion was really constrained to just that case. So it did not overturn the underlying precedent, which is Illinois BRIC, which has the direct purchaser rule, and maybe that should be overturned. The court was never asked to do so. There's a lot of theory there, but essentially they said yes, and their reasoning was, I think it was superficially correct. It was one of those opinions where they got to the right place, but it was more rested on the fact essentially that you can log onto your iPhone and click purchase, and I mean that makes sense as a very basic rationale, and I think the court got that one correct. There was a private suit though, which is notable, and that was brought through citizens and not brought through state AGs or through the DOJ or FTC.
Interesting. So what they were doing then that violated it was they were saying we have the App Store, and they were putting up charges there, but you could only buy basically the apps through the App Store. So they were passing on extra costs, is what you're saying?
Well,
I actually don't know those cases well.
It doesn't necessarily mean that they're guilty of antitrust violations. It gives the consumer standing to sue. So we'll see, as this litigation plays out, whether or not plaintiffs become successful. And I think, maybe in a few cases they will, and a lot, with any sort of anything that involves a plaintiff's bar, you do have a lot of cases too that probably won't survive on the merits. But it gives them that capability, which is really important, I think.
Interesting. Okay. And so as we're talking about big tech, I think that's the place where the antitrust, the reason why I think this debate has come up recently is because you have Google has like over 90 something percent of the search traffic. Facebook and Twitter are the two social media platforms, and we've seen them, gang up to shut down other social media platforms with Parler between the different tech companies and Amazon. I don't remember the last time I bought anything offline that wasn't off Amazon, just because they're the one place that you really can go for it now. Uh, with all of these big tech companies and the way that they've also been wielding power, how should we look at this from your perspective as someone who works in antitrust? What are some of the solutions you see to maybe restraining some of the power that they've been, I would say, misusing or overstepping their bounds on?
Yes, so let me like back up a bit to fill in a bit more about what's a violation of
Mhm.
antitrust law and what's
That's
just
helpful.
a company being big, and then also how, there are lots of things that can be done about corporate power
Mhm.
potentially. But you mentioned Amazon. My quick point for that is Amazon actually nationally does not have that big of a percentage of the retail market.
Wow.
I think that one's a little bit skewed. The other companies, I mean, they are massive. So was AOL. So I mean, look at Microsoft.
Yeah.
Which that's another case, that's an example. That one's a bit more complex. The Google case is a little bit modeled after that. They eventually failed to innovate and move into the mobile market is what really brought them down. So you see over the years, MySpace was their headlines that says MySpace is the next monopoly. How do we take down MySpace? How do we take down LiveJournal as one that was in
Yeah.
like Forbes or something?
Yeah.
And these are cyclical and they're eventually replaced. I do see, concerns about the amount of data they have and about their current size and the actions against like Parler, for example, or just content moderation in general. A
Mhm.
lot of those though are not competition law concerns. So competition law in the United States, at least, it is not illegal to harm your competitor. You just can't harm the competitive process and therefore harm the consumer.
Yep.
So, the nature of competition is essentially you are harming the competitor in one way or another. I mean,
Mhm.
there's certain things that are illegal, obviously, under lots of other laws, but in the EU, to kind of juxtapose it to that is you can't harm. It protects the competitor, and there's a reason why they don't have these large companies like we do.
Mhm.
So, as imperfect as they are, at least we do have them, and that's really important right now, and from a competitiveness perspective. But yeah, that's kind of the core of the problem is who is harmed, and it's hard to prove consumer harm in some of these cases when they really lie in more the area of like privacy law. Okay, I think that we need to pass a federal baseline privacy bill. That would be very helpful. We need to actually enforce our intellectual property rights more
Mhm.
strongly, and larger tech companies are some of the biggest infringers on IP.
Mhm.
And I think really patents are kind of one of the best anti-monopoly devices ever invented, because you can have someone who's just like anyone come out of left field with an invention that they came up with and disrupt an entire market and have a property right in that new invention.
Mhm.
And that's really quite strong, and that's something that I think even for the sake of some of the companies and the businesses too, it should be enforced. There's a
Mhm.
lot of copyright infringement, for example, online, especially during the digital age. And patentability is a huge issue as well, especially after Alice. It's harder and harder to get a patent if you're patenting software. So that's one thing that would help. I'm not an expert on Section 230. I know that's a huge controversial issue. I have some thoughts about that, but I think I haven't seen a solution that I really like to that. I would be in favor of something that in a very targeted way narrowed it.
Mhm.
Doing it away with it entirely would make the problem significantly worse for
Mhm.
everyone. But and like I said, I'm no expert in that, so I don't know what effective 230 reform would look like.
Mhm. Yeah, it seems to me I do like your point that you made about it's not wrong to be big necessarily, and that's, I think, important. It's about abusing your power and disrupting the ability for others to compete. That's really what I think bothers me the most. And I don't necessarily have a problem with companies that get big, because I know, like you said, with MySpace, but they also, I think someone posted that next to like it was like MySpace next to Facebook, and Yahoo had the same thing where it's like Yahoo's the next monopoly and then next to Google. And you're like, oh yeah, a lot changed. And those things were in the last 15 to 20 years that those rose and declined. So there is obviously that competitive landscape for people to do that. It's, I guess, when they are abusing things, like one of the things that I've seen is I built up a Facebook page that has 1,000 followers or so, and 3 people see a post each time unless I pay a bunch of money. And that was not the case when I signed up. It seems to me that there's a lot of bait and switching and unclear stuff about rules for, like, as a content creator, how they distribute my content, and they change it constantly. And I get
Mhm.
that they're trying to improve the algorithm for the user in some ways, but they also are, it seems like there's a lot of fishy things happening there from the creator side. And I think, I guess I wonder what sorts of things can be done about that. I know that there's people bringing fraud or false advertising lawsuits against Facebook. Um, but do you see something like that, like maybe individuals suing the companies because of things like false advertising, fraudulent, or not upholding their terms of service, things like that, versus an actual government action would maybe be the best way to put a check on these companies? Or do you think the government needs to step in?
Well, I think you do have a good point regarding the terms of service, and that's a case by case sort of thing.
Mhm.
I do like what you brought up with your page, though. And I think there are a couple of aspects going on there. One of them is actually a bad thing, but a good thing for corporate power is that these algorithms are kind of getting a lot less effective. As they're not as effective as what they used to be. And some of that's because of regulation. And some of that's because, too, just having a ton of data, the more data that you have, it's not that as if it gets better. You hit a point kind of a diminishing returns. You can't really build a data moat that is so deep. There's this great Andreessen Horowitz article about data moats, like what it's advising mid-sized company at what point should you stop investing in getting user data. And it
Mhm.
illustrates a really good point. But there are solutions in contract law. I think privacy law. There's a lot of issues there. But I do agree with you that they make up the rules as they go. Well, Twitter particularly makes up the rules as they go. Some of the others I think make more good faith efforts. And
Mhm.
sometimes too, so when you see all these tech hearings, you see people from both sides of the aisle. They both want to regulate them. They both want to, for example, reform 230, but they have totally opposite reasons for why they want to do it. The left wants to do it so they can crack down more on speech, and the right wants to do it so that their content won't be regulated, which in reality is not really what's going to happen.
Yeah.
And it's there's also this push and pull in that they bring the CEOs in front of Congress and kind of tell them what they want, and that certainly affects how they behave. But they're being told from both sides. I think which one they if it's I don't know if it's a matter of which one they decide to listen to, or just conflicting messages, or just trying to appease them and not have a disastrous regulation.
Mhm. Yep, I think that's a great point. And I wonder if, I guess what I wonder is, how can you take some of those companies and, I don't know if it's Section 230 or what, but make them liable on the intellectual property side, like at least make them choose, because right now they're playing this in between space. And I think this is something that a lot of conservatives are upset about, where it's like, we're just a publisher, but also we're really curating content a lot, and we're pushing certain things down in the algorithms and pulling certain things up. So it seems like they're really playing both sides of it quite a bit to get all the benefits of being a publisher, but also all the benefits of being able to push, what they, or rather, sorry, I should say all the benefits of being a platform, and then also being able to kind of act as a publisher in many ways. It- Do you, I guess, do you think that that's something that needs to be reformed first, or do you think that there are other channels that we should look at if we want to curb some of their abuses that I think are pretty evident?
So I think that's one tool in the toolbox. And I'm overall, I think that 230 has done more good than harm through the years.
Mhm.
I do think it perhaps needs, I'm glad that Congress is revisiting it. But the publisher platform dichotomy is not exactly how it really works in the law. It's more like distributor of content versus publisher. And I think it's hard to decide really which, what to take down. But I think illegal, like pirated content, is a very obvious one. There should be more enforcement of that, for example. But to their credit, the platforms do a really great job of taking down the truly awful stuff. And I was not aware of how much really awful content there is on these platforms. And not just their percentage of getting, which I know there's the New Zealand incident recently, but they get like 99.8% or something of terrorist related content picked up before anyone sees it. So the algorithms have gotten pretty good for that. They need to help that for like IP, but then, you have the problem of potentially over moderating. So I think, overall, I prefer less moderation to more, and I definitely prefer more speech to less. But I don't know. It's a tough question. Like I said, I don't know what a nuance, look at 230 look like. I know the phrase otherwise objectionable is something a lot of people talk about, how that's very broad and was intended to be broad at the time. Maybe we need to look at that. I don't know what a solution would look like. Privacy is another issue, though, that I think we need to tackle. And, we were getting to earlier about, Parler and the situation of not being able to start up companies. I would bring up one point on that. So I was testifying before the Senate Judiciary Committee on Antitrust about 3 weeks ago, and Senator Lee asked me a question. It was a very good question. And he was saying, they tell you, you should build your own. They tell you again, you should build your own, and then you can't build your own. And then something like, Parler happens. And I won't get into the specifics of the Parler situation because it's legally a lot more complicated than it seems. It's not really as much of necessarily an antitrust issue. It's a problem, but it's not necessarily an antitrust issue. But I would point out that, there aren't that many entrepreneurs who are just building another Facebook. Sure, some people want to build another platform for conservatives or for a niche, but the innovation is going on in things like Clubhouse, for example. Look at the massive VC investment in that recently. Entrepreneurs, they kind of, they come in from the side, not to replace, so to speak.
Yeah, so this is my side thing that I enjoy doing, but I do work in a tech company, and I see a lot of the tech companies in our space, and it's really interesting what they're able to create, for sure. But yeah, I think that Parler thing seemed very, very fishy, as you just saw a domino effect of like, I don't know, everything kind of getting taken away from them one by one. And I guess here's another one that concerns me is companies like Stripe, or I don't think PayPal's done this, but Stripe I feel like has, where they'll not process payments for certain people. And, you know, it's like, how far are you from the point where because of your political views, you can't get a Visa card either, when they're discriminating on those sorts of things. I think that's another place where I don't want to overregulate, but you also have to be concerned about the fact that all of these things seem to be targeted at a certain section of people as well, because it's generally targeted at conservative content creators or conservative businesses that all these companies seem to gang up. I don't want to say gang up against, because that's probably legally opening myself up, but they're for accusations, but they all seem to be against the same things ideologically.
Yeah, and I would add that they're not against the same things because there's collusion, because that's what arguments can be. They're just all, again, they're all liberal because they're Silicon Valley companies, and one of them makes a decision to take Trump off the platform, and like once the first shoe is dropped, then the rest of them do it. I don't know as much about the issue relating to Plaid and people. I have heard a bit about that happening. I think that's less of a frequent occurrence and a contract violation. But I don't know if there's a way to maybe make these contracts so that you can't necessarily discriminate. I know I've seen some proposals to essentially on the state, and even I don't think this can happen on the federal level, but make conservatives a protected class under civil rights law. I'm overall wary of opening that up because of where it has been opened up in the past, but it also has been opened up so broadly already. I don't know. I'm not a civil rights attorney. I think that's a creative idea. I had not heard that until recently. And I don't know if there's a way to apply, like fair, reasonable, and non-discriminatory terms to these contracts without them being public utilities, because you don't want to go into the territory of a company becoming a public utility. That's when you really have the over-regulation concerns.
Yep. Yeah, I thought about that too, and it's almost like then you have to let Democrats into the GOP and Republicans in and all that. Like you can't, so that would be very tough to not be able to
discriminate. The wrong way, it's illegal. Like, yeah.
Yeah.
Then you're excluding other, specific protected classes that are already, it gets really complicated, I think.
Yeah.
What some of my concerns though today are, obviously the what the platforms are doing is bad, but I look at antitrust law through the lens of more broadly antitrust, and not, I don't look at this as specifically a tech issue. I suppose because I was working on a lot of these regulatory issues before they became tech issues, and now unfortunately they're tech issues.
Yeah.
But a lot of the proposals that are on the table today would go way far beyond the tech industry, and those would really upend the consumer welfare standard, which came into being around 1977, was recognized 1977, 1978. Then a year later, the Supreme Court actually recognized the Sherman Act as a consumer welfare prescription. And that's been, since then, has developed as the guidepost. And it's become this neutral underlying standard that is, it's not statutory, obviously, it's a set of principles that guide rules and regulation and analysis that gives judges something to go by, something that's tractable. Because before that, antitrust law in the 1960s and 50s was a complete mess. It was being used for, and speaking of using things for left-leaning purposes, you can use antitrust law for environmental purposes, for redistribution of wealth, which is what they're blatantly trying to do with it right now. You can use it for like any left-leaning cause under the sun. The right can't really use it for much. I mean, not that we should. We're principally opposed to that. We're also not very good at it. At the end of the day, they have decades of experience doing that. Is something I say halfway jokingly, but the law can be weaponized very easily in this area, especially considering that it took so long to develop, and that's why I wish a lot of conservatives would realize, that they're really tearing down a fence that took a long time to build, and it's built for a reason.
Yep. And the consumer standard is basically that what antitrust should be applied when the consumer is harmed, correct? That's what you're talking about here?
Well, when the competitive process, which is dynamic, is harmed, and that causes harm to the consumer.
Yes.
It's a bit broader than that. And one misconception about the consumer welfare standard, by the way, you hear a lot of people saying, well, it's only concerned with price. How do you apply it to digital markets? It's been applied to a narrow set of other things since then, effects on innovation, supply, several different factors. The Microsoft case, for example, is an example of non-price factor. So it is a bit broader than that, but it's not broad enough that anything that doesn't belong there within competitive law, that nothing there can be addressed. And it gives a guidepost for judges.
Yep. Yeah, like it doesn't matter on price in the medical world if it means that you're not getting, you're doing something maybe to not allow new drugs to come to market or new innovation to happen there that could cure illnesses. That could be something where you're harming the competitive world, but it may not affect my price, but it may mean that we don't have access to new drugs that could potentially come and cure us of illnesses.
That could be, that could be one analysis. It could be, if that analogy taken to the extreme, something could be per se illegal. That's when you have, kind of the really bad criminal behavior, which it's pretty black and white actually. And those are the really bad cases that really do protect consumers, or the naked price fixing type cases and cartels and that sort of issue.
Okay, that's really interesting. And so we've kind of gotten into how these things get enacted a little bit here and there, but I'm curious because you also work with holding judges accountable as part of your work, and you mentioned that it's not as much looking at them after they're in, but how like vetting them as they come in and their nomination process. So what could you give people a little bit, I guess, background on what you do there and what that work entails?
Sure. Let me tie that into antitrust first, if that's okay. I think that actually there's a commonality between what I'm about to talk about in the consumer welfare standard, but there's this misconception in people who are talking about antitrust now who do support constitutionalist judges who are saying that antitrust law was developed, the way it was developed was through judicial activism. which isn't true because as the history of the Sherman Act said, and as Amy Coney Barrett said during her confirmation hearing, by the way, and also Justice Gorsuch said during his, as Scalia said, well, he said during his that he didn't understand antitrust law during law school because there's nothing to understand, and that now he does. But it keeps judicial activism kind of out of the antitrust litigation. So, I mean, those two things are mutually exclusive in that you could have something that develops essentially as common law through the course and also have activist judges, but that's when you get, a ton of rulings that are completely unpredictable, and you have the ability to apply it to other policy motives. So that's something that keeps judges on track. And to kind of to circle back now to what I've done on judicial confirmations. So my organization, we work on helping confirm and confirm constitutionalist judges, textualists, and originalists who are going to uphold the text of the Constitution as written. We also analyze their lower court records. We talk about Supreme Court cases, a number of them that are on the docket each term, and about federal judges as well. And we really advocate for a strong constitutionalist judiciary.
That's really interesting. And so that's actually one thing that I am curious about, because at least one thing that you mentioned is checking people's records. Because I hear, as a layman who has not gone through law school and everything, I hear this all the time when a Supreme Court nominee comes up and they're like, oh yeah, we're looking in the record, here's this and that. What sorts of things do you look for, and how do you research that? Just their previous cases and what the arguments were and how they decided, or is there more that goes into it?
Right. I mean, aside from the basic set of things that would get them nominated in the first place, such as, background, where they've worked, you have to make certain steps in your career to eventually get appointed. You start with the cases, with their opinions. And how many opinions that you have and what types of them you have to evaluate really depend on the nominee. And but Kavanaugh, for example, he had a long track record of 303 or something, I think, opinions written in the DC circuit, and you're going to get a broader variety of things and more cases related to administrative law and the government there. Whereas if you're stuck out like the Sixth Circuit, you're going to have a totally different caseload. So so you do have to look more at principles, and that's why it's important to look at principles and not at outcomes. And they have different amounts of time that they've been on the bench, and I don't think more time on the bench as a federal judge necessarily means that they will be a better justice. A lot of people criticize Justice Kagan, for example, and she's Solicitor General, but I think that's very relevant experience. I think it is possible to not be on the DC circuit for 12 years before being confirmed. I'm definitely not advocating for someone with no experience, but there are different types of experience, and there are still things that give you insight into how they will rule, as long as there's enough of that record. We look through that. And then secondary is kind of any of their extrajudicial writings, as they're called, speeches given, involvement in Federalist Society, American Constitution Society, ABA, and university speeches and what they've written is kind of a secondary consideration to kind of get a bit of insight into how they think and how they might rule.
That's really interesting. I've always kind of wondered what all goes into that beyond. I figured that you look at their cases and where they went to school, but that's interesting. Okay, and then so you mentioned that you worked on the Brett Kavanaugh's nomination from behind the scenes. I mean, a little bit, as much as you can maybe tell. What's that sort of process look like for you, and kind of what's your role in that?
Well, for any of them, particularly, let's just stick with the Kavanaugh vacancy, because his cases were relevant to my expertise, actually, and so that worked out really well. He had a ton of administrative law opinions. I think like 103 or something of his opinions were administrative law and agency related. So I first approach things from that area. That's my expertise. See how he looks at agency deference and different mostly issues involving government agencies. A lot of deference, a lot of Fourth Amendment is something else that I've focused on quite a bit, and anything that involves like really commerce some of the Second Amendment stuff is there are other people who are better at that than me, but those are really my focus areas. So with the Kavanaugh confirmation, there's plenty of material for me.
Mm-hmm. Yep. Okay.
And he was great on those issues. So
yeah, and that would be basically saying, when a law gets passed and they're like, okay, EPA, you decide how this gets implemented, and that you're saying that those sorts of cases that come up then when people push back against the EPA doing something, those sorts of administrative laws, that's where you're focused in.
yeah, so I mean, they arrive at the DC circuit in that case in different ways, different legal challenges, and whether or not who should interpret a law that's ambiguous. Should the agency interpret its own rules? And those there's still a lot of lingering questions regarding that. But it also gives a good insight into how do they read the text, what statutory interpretation. That's really important. I mean, it's Frankfurter who said, first thing you do is read the text, read the text, read the text. I think that's a great quote, and how they apply that, I think, makes a lot of sense. And one thing is, during the confirmation hearings, you can't, well, some people do, but they will not answer questions related to how would you, any sort of hypothetical about how they could potentially rule in a certain case, or any question that's disguised as something else. It's basically how would you rule in Roe v. Wade or any other matter. And it's one thing, just to make one last antitrust point, is there's actually a House Judiciary Committee hearing about 2 weeks ago, which a Seventh Circuit judge, who was actually considered a front runner for 2 Supreme Court seats during the Obama administration, or as close to a front runner, was testifying on antitrust law. And I think it's completely appropriate for a judge to come testify about cameras in the courtroom, things that affect the judiciary more broadly. When it comes to this more substantive type stuff, you're giving their future litigants who are watching to see how you might rule in a case. And that's one of I would say 2 reasons why those questions can't be asked in confirmation hearings either. So Ginsburg actually, so this is called the Ginsburg standard. She started doing first during her confirmation hearing. She refused to answer any questions related to how she might rule another case, or she said no hints, no forecasts, no previews. And I think that's so great that that is a good standard to have.
Yep, because I think it then circles around the philosophy that you have, and you can have it, and it brings back the debate then every time you have a Supreme Court nomination, like the textualist versus, I guess, originalist is slightly different, right? And then I don't fully know the distinction between all the philosophies, but versus something that's more loose on what, an interpretive, you're able to have that discussion and allow the people to vote in someone who's going to rule with have a certain philosophy that they bring to the bench, rather than just, I don't know, electing another senator who's going to vote a certain way. Basically, is what it kind of changes what you're doing there, it seems like.
Well, one side would certainly like that. They would kind of like the more politicians in robes, and that's that's the core of the differences between the textualist and originalist camp and the judicial activists and living constitutionalists, is they're focused just on outcomes. Really. They're focused on policy outcomes. They're not focused on specifically the guidelines, the rules. How do they get there? And we also have, as conservatives, have a further uphill battle to climb in, in overturning any sort of bad decisions too, because by nature, conservative jurisprudence is very incremental. It moves very slowly. Conservatives are less likely to just directly, overturn Roe v. Wade in one fell swoop. I'm not saying that'll never happen. I'm just using that as kind of the stereotypical example of how cases are, it takes a while often. And that the dynamics of the court have shifted differently. And one big thing about each new appointee is every time there's a new justice, it changes the overall dynamic of the court, both in little ways, and that it's little ways in which it influences kind of each justice just by having that new person there, but also in the broader scheme of things. Even if you're not close to just a 50-50 split, or 5-4, sorry, not 50-50, but if you're going over one way or the other, it's the direction of the court is really what it's about usually, as opposed to it being about the individual justice.
That makes a lot of sense. And so you mentioned that you work with looking to get constitutionalist and textualist judges in there. What what is the difference then between the textualist reading of something versus like originalism, or is there a difference, kind of like a distinction without a difference? Because I hear both of those. It seems to me, from my perspective, that the Gorsuch case, where he decided with on, I forget what it exactly was about, but that transgenderism somewhat, it affects men. It kind of is discriminating based on sex, because you're saying that then a man can't wear a dress, whereas the originalist look of it might be, well, that's not what we weren't looking at. That we were trying to make sure that based on this law that you weren't saying, no men allowed. Not, I don't know, is that like the originalist maybe takes more context into what people meant versus the textualist is saying, here's what the law says? Is that kind of the difference?
That kind of sums up at a really broad level, but they're often kind of the same thing. One
Mhm.
can, talk about original public meaning versus, statutory interpretation. Sometimes those can diverge in how you interpret certain specific laws, but overall, they are, parallel, coherent, intertwined,
Mhm.
to like, methods of jurisprudence are very similar. Going back to the case you're referring to, though, that was the Bostock case, the Title
Mhm.
VII case,
Yeah, yeah.
which a lot of conservatives are very, very mad about. The backlash over that, I understand that it was a big monumental case. I don't think that his decision there meant that Justice Gorsuch was becoming a judicial activist.
No.
And it seems that it was interpreted by a lot of people that way. And that there are a lot of people who are even saying, we should abandon originalism because of that one decision, which is, I think, really ridiculous. Like I was talking about, tearing down the fence that we built for a good reason. It took the conservative legal community a long time also to get to where we are now with the majority of
Mhm.
the court. And once we see that basic underlying principle that we have, then we give it all away.
Mhm.
We don't have anything. But that particular opinion, in my view, his analysis, I think, was flawed. I've described it as, and I've heard other people, I think, use kind of the same term as hyperliteralism.
Yeah.
He took the very, very basic literal meaning of the word to an extent that was almost over analytical in a way that just did not comport with the law.
Mhm.
And I think it was, they don't bat at 100%.
Yeah.
And that was a big case to, swing and miss at. I'll give you that, but it's not the end of the world. I think he's not at all likely to become an activist judge. I think he's one of the ones who I have pretty strong confidence in will
Mhm.
not drift. He's not going to be he's not Justice Souter because of that.
Yeah.
It's ridiculous the amount. And there's the argument now for common good originalism. A lot of it sprouts out of just that opinion. There were a couple of people who have been making that argument since beforehand. Their arguments are a bit more nuanced in some ways that I won't get into here. But there was definitely a backlash after that opinion saying, oh, your originalism, it isn't working
Mhm.
because of this one case. And oh, you've been appointing the wrong nominees for years. And there have been very specific reasons why they have been good nominees and will continue to be good nominees. Sure, Roberts has been a disappointment, but I think the person who would have been appointed instead of Roberts have been a much more of a disappointment than
Yeah.
Roberts was. I think there's a lot of historical context that they're missing out on as well.
Mhm. Yeah, I was gonna say it's not like he's Roberts yet, or anything like that.
Yeah, he will never be. He's nowhere close to being
Yeah.
Kennedy,
No.
for that matter.
It- He and that's the thing is, it was one bad case, and I think the next couple weeks, a couple things came out that were showed real solid, like pretty hard line, no nonsense as well on cases that you wanted that he shouldn't have been messing around with. So that was good. I think it. I listened to a lot of Catholic radio, and Catholic radio was not very happy at that point
Yeah.
after that. But and understandably so, because you would hope that he would have probably. I think it was decided wrongly, and I didn't like his logic when I was listening to it read. But I also am not an expert, so you know, I have my thoughts, but I also know I didn't study for a lot of years, so I find it hard to criticize people like him or people in your position who have really gone through it. I've taken one business law class to get through my marketing classes, so
I
there's
think
not.
anyone can read and understand, a lot of these cases. But
Mhm.
I do think you have to ask yourself: are these people Are they upset about the outcome? Which is fine to be upset about the outcome and the reasoning. That's a totally reasonable
Mhm.
position. I agree with people on that. But some are not as concerned about how they got there.
Mhm. Yep, exactly. And that was my thing is I didn't like the twist that it could be because then it's like, well, anytime you say no to a man on the basis of him being a man, then you have a lot of, or the way people dress and all those things that kind of opens it up for, I don't know, almost too wide a door on that with that very hyper focused reading. It's like there was the guy who wanted to start the Church of Cannabis so that he could smoke pot for his as part of his religion. It's like, well, you know, we had under that reading, maybe that would stand, but I think they, at least Indiana, I think it was Indiana Supreme Court struck that down. I think it was here in Indiana when that happened a while back. Probably happened in other places too, but yeah. So,
Of course,
oh,
this
go ahead.
is methodology that reminds me of this quote that I really like from Judge Learned Hand. He said, "You can't build a fortress out of a dictionary." I think that's really applicable there.
Hmm. I like that a lot. That's awesome. And so, what are some paths forward with someone who's been in hearings and Senate hearings and things like that? What are I guess what would you say is one of the biggest problems facing us right now in your area of expertise? And what would you say is the ideal solution for that based on your work?
So by we, do you mean just all of the United States, or specifically my kind of camp, so to speak?
I would say biggest problem you see facing the United States at that policy level, like what the biggest problem that we have to figure out going forward, and what is that solution? Whether that's some of the things that we see with our senators who don't know the first thing about the internet, asking trying to write antitrust laws against Facebook or whatever it might be. What would you say that is that biggest problem?
I'd say there are two or so primary
Mhm.
problems, and one is that Congress has usurped all its authority to the executive branch. They've ceded all of their power. They're no longer legislating. Even as bad as I complain about these legislative proposals, how bad they are, they would have to go through more of a legislative process to in order to pass legislation, and that would be a good thing to restore the role of the first branch. And you also have the fact that the Supreme Court, you should not have national protests every time a justice passes away or retires, or
Mhm.
every time there's a hearing. And there's far too much power given to and focus on just 9 individuals.
Mhm.
That said, there's court packing is a proposal
Mhm.
that is still, I would say, somewhat gaining steam. It would take a lot for court packing to actually happen. We would have to no longer have the filibuster to start. I think that would probably fail. There are enough on the left who realize that would be bad for them in the long run, but that's a really dangerous idea. It's historically, court packing proposals have been there. There have been several periods of history in which you've seen a lot of these, and it's not just in the New Deal era, but through the years, these court reform type proposals, they're used to influence the judiciary and influence outcomes.
Mhm.
Particularly, there are studies that influences the Chief Justice the most.
Mhm.
Although I would argue there are lots of different ways right now to influence John Roberts, or some would say that, but it's definitely been used as a tactic too. So even in that extent, even if they're really going for that goal, you have the court restructuring issue.
Yep. Yeah, it may not even be about actually packing the court. It's give us this decision that we want now, or we will do it. Sort of, it's kind of holding the court hostage to rule a certain way. I mean, that's
Mhm.
really what FDR did. It was pass my stuff that you think is unconstitutional, or I'll just pack the court. Uh,
And that has
I
an influence for years.
yeah,
Um,
yeah, it did. And I think that to me seems like a huge threat right now. And I liked your point about the Congress ceding all of their power to the bureaucracy because my representative is fairly entrenched. I don't think we're getting Andre Carson out anytime soon.
mhm.
But considering he's basically inherited that from his aunt, but it at the same time, there is a possibility of voting him or a senator out, whereas I can't vote out the EPA agent that's just saying, here's how I want to interpret this law, and that's how it's going to be.
Yeah, I agree with that. One last point about court packing verse though is I mentioned, it is used to influence the Chief Justice, but I would add, and also kind of somewhat in defense of Chief Justice Roberts, is the Chief Justice has a very much invested interest in preserving the court as an institution.
Mm-hmm.
And that's a very strong, compelling interest enough for them to want to, rule maybe a certain way, or nudge themselves and into a certain direction, or nudge the other justices. That's kind of how that happens. But yes, that's a great point. And I mean, you have your political appointees, obviously, but you also have the fact that there are lower appointees who are, being stuffed into agencies that are there for a very long time. You have civil servants, and a lot of it too is these agencies become, I mean, there's so much red tape. I mean, it's a bigger regulatory problem that you have these behemoths that do not function well, and are packed by different political parties, and there are a lot of dynamics there, a lot of inefficiencies.
Mm-hmm. Yep, I agree. And it's just a incredible swelling up of the federal government and the budget because of that too.
And antitrust, by the way, I think is one of the the consumer welfare standards, one of the largest narrowings of federal power in the past half century, I would say.
Yeah, and so some of the things that the proposals that we've seen on antitrust front would be potentially doing away with that in a foul swoop, whether it's from the right or the left, because of a lack of understanding, really, of what right is. That was
It
kind of
depends on the
what we were getting at earlier.
proposal, but most,
A
yes,
lot of
most
them.
of them are pretty damaging. There are proposals out there that aren't so bad, and eliminating exemptions, for example, from antitrust law. That's something I could support. Maybe giving agencies, and I never argue for increased agency budgets. I was just talking about inflated agencies, but maybe they are a bit. They do have not as many resources they need for those specific cases. Allowing them to pursue a bit more litigation, that would be helpful. Allowing them to pay their attorneys like market rates, so they're not going off to tech companies instead. That would all be helpful, I think. And there are certain things that I could get behind. But
That's
changing the underlying legal standards is not one of them.
Yep. I appreciate that. And great. Well, I think that wraps up our questions for today. Do you have anything else that you wanted to touch on before we sign off, or anything else that you wanted to add on that?
Gosh, I wouldn't know where to begin. I could talk about confirmations for a long time. These are both really broad issues that are really hot topics right now. I think I'm glad the conservative movement is having this conversation, by the way, over common good originalism versus originalism, and I think it's breeding a lot of good conversations that need to be had. I think that one side of it's completely wrong, but I do think that there's some good in having that. I'm worried of that division splitting the movement apart.
Yep. I know that for me, I've come from a very hardcore libertarian side of things to be much closer, aligned to a traditional, more common good, even conservatism. I still think, I still have very libertarian views when it comes to federal government versus me, but at like a more local level, I see a lot more of that common good thing playing into it. And so I know I've been moved, and I see a lot of people that are young conservatives that are even probably more on the side of a traditional way of doing things versus people my parents' age, who I would say, when they're conservative, are a little bit more libertarian on things. Your kind of Gen X level of people seem to have that kind of 80s Reagan sort of, or at least how the 80s Reagan movement is portrayed in that, uh, you know, big business, trickle down type of thing. So
I
it's
think the
interesting.
nationalism brand of conservatism is dangerous right now, particularly as as the economy is trying to repair from COVID, as we're competing with China. I think it's really short-sighted, and those values there's a lot of tech bashing going on. That's why antitrust has become such a tech issue. And when they've realized, oh, well, privacy law is really hard to pass, it's really hard to amend 230, they view antitrust as this hammer, and you're going after kind of everyone. Just kind of like throwing darks in the dark. And or even I've seen over the past few days is the unionization votes with Amazon, conservatives arguing like in favor of those unions in ways that just would make absolutely no sense. They're saying things that are contradictory with Citizens United. There are some really core things that I think some of it too is a matter of those views have not maybe necessarily developed with some people. I mean, that sounds, I don't mean to sound condescending in that way, but I think some of this is a learning process in terms of the context, and they kind of came into it from the Trumpian perspective. And I wonder how much of it is that factor and how much of it is really people rebelling against the establishment.
Yeah, it's like there needs to be a correction back towards that somewhat maybe, but I think that there's an overcorrection in the strong, like, tariff everybody everywhere. And I'm like, I think there's an argument to be had about, if China is going to play dirty and subsidize their steel and do all this stuff to, fight against us, then okay, well then tariff Chinese steel, if they're subsidizing it,
Argument's legitimate.
correct.
Yeah.
That type of stuff, targeted things like that seem to me like they make sense in preserving a free market and protecting, yourself against a sort of a financial attack in that way, or economic, attacks. But there's also this sense that it's like, we just need to tariff everybody. And I'm like, no, that's not this broad-based solution that's going to help everything. It's just going to raise your prices amid what's already going to be probably a highly inflationary period anyways.
Yeah. I mean, one thing to kind of tie all this really together is, so I've said for quite a while that, there's a massive overlap between the antitrust populist, I'll call them, on those who want to weaponize antitrust on the right of center, and the common good originalism movement, nationalist conservative movement. I mean, so much. If we had a Venn diagram of the two, it'd just be a complete circle. There's 100% overlap between these two issues, and it tells you, really, at the end of the day, this isn't about originalism. It's not about originalism. It's not about antitrust. It's just about power. They were out of power when the establishment was in power, and these are different, ways of approaching that, whether it's, getting power from the left or from, within the party. This is not really coming as much to surface until after Trump is no longer in office, and now it's, the Republican Party has been doing it wrong for decades.
Yep. I think that's an interesting point, and I think that is a pretty good note to leave it on. So I probably ought to get running, and I know you probably ought to get running as well. So thank you so much for coming on today, Ashley. I really appreciate it. This was a really interesting discussion. So thank you so much.
It was fun.
Yeah. Awesome. Well, thank you. I don't know about you, but I was amazed at that interview. I need to go back and listen, because I think I was understanding and following along, but I need to really digest it, because especially with the legal stuff, I know for me, I need to kind of hear it again when I'm not trying to follow in a way that I'm hosting a conversation, right? And making sure that I can dive into the details and catch more as well. So definitely need to go back and listen, but hopefully you got a lot out of this. If you did, make sure you subscribe to YouTube if you're watching there, or the podcast, wherever you're listening, or just to the blog, or even my newsletter. You can subscribe, conversationofourgeneration.com/newsletter. And if you go there, you'll get my weekly rundown of top discussions that also includes the 2 podcast episodes for the week. But we'll also have a lot more of what I'm listening to, watching, etc., reading even sometimes. So definitely check that out, because I think it's a great way to stay up with kind of week to week what are some of the big trends and topics that are affecting our dialogue as a society, as a culture. And so I think that is a great thing that I try to help offer. And then also, if you want to support my work, go to conversationofourgeneration.com/subscribe. For just $5 a month, you can get all the premium content, access to my Discord channel, any future premium content that comes out, as well as a copy of my book. So lots of great stuff for just $5 a month. I've already had some people rolling through and subscribing more and more, so definitely check that out, because I think it is a great value and it's a great way to support what I'm doing here. But if you just want to do it for free, subscribe to the newsletter. You can share the podcast, share the YouTube videos, all of that stuff. Follow me on Twitter @ConOfOurGen. Those things are free, painless, easy ways to support what I'm doing here at the Conversation of Our Generation and get more people involved. And so thank you for listening to this episode. I hope you got a lot out of it. I hope you enjoyed it. And let's get the dialogue going. I'll talk to you next time.